In order for a tax debt to be dischargeable, really in any chapter, it has to satisfy three requirements, and all three have to be satisfied. The first requirement is called the 3-year rule, the 3-year requirement. And what it says is that the tax return for the given tax period, whether it's a year such as income tax or maybe it's a quarter such as sales tax, the tax return must have been due, with extensions if you got them, at least 3 years before the day you filed the bankruptcy petition. For example, let's say you were trying to get rid of 2018 income tax debt. Well, how much time would we need to wait? When is the 2018 income tax return due? Well, it's due in April 2019. Some years it's April 15th, some years it's April 16th, one year it was April 17th. So 3 years after that would be in April of 2022. So if you wanted to get rid of a tax debt for 2018, you'd have to wait until 2022 to satisfy this first requirement, the 3-year rule. The second requirement is called the 2-year rule. And it says that you must have filed a legitimate, non-fraudulent tax return for the given tax year at least 2 years before the day you file the bankruptcy papers. Now notice the difference between the 3-year rule and the 2-year rule. The 3-year rule asks, when was the return due? The 2-year rule asks, when did you actually file it? And then the third rule, or third requirement, is called the 240-day rule. And it says that the tax you're seeking to discharge cannot have been assessed by the taxing authority during the 240-day window immediately prior to the day that you file the bankruptcy papers. Now, 240 days is 8 30-day months, because if you think about it, 8 times 3 is 24, so 8 times 30 is 240. So that's when the tax was assessed, or up till the time it was assessable. Now, if you had a prior bankruptcy case pending during one of those 3 time windows, the moment you filed the bankruptcy case, stop that clock. Once that bankruptcy case is concluded, either because it was dismissed and closed or you actually got a discharge, then that clock starts up again, but then you have to add 90 days at the end of that clock. If you had something like an offer in compromise with the taxing authority, same drill. Once you submit the offer, that stops the clock. And then once the offer is over, whether it's because you satisfied the requirements of the offer or because it was rejected, then the clock starts up again, and then you have to add 30 days. Now, if the taxing authority files a return on your behalf because you never got around to filing the return, then that tax debt is not dischargeable in the Ninth Circuit. Now, what I have been thinking in terms of in the answer to this question is taxes that are income taxes or sales taxes. Trust fund taxes are never dischargeable in bankruptcy. So, for example, payroll taxes, where if you have an employee, you're going to pay the employee, but before you give the employee the check, you take out the taxes that you're supposed to send to, say, the IRS, or in California, the Franchise Tax Board. Well, if you haven't done that, you violated a trust, because the money you took out of the employee's check was never your money. It belonged to the taxing authority. You held it in trust. And if you don't remit it and now you owe that money, that is not a dischargeable debt in any bankruptcy case. Now, the question posed was in Chapter 13. And so for most people, when they're thinking in terms of is a debt dischargeable or not, they're thinking in terms of Chapter 7, where the debt just gets wiped out, end of discussion, you don't pay a dime. But in a Chapter 13, you have a multi-year debt repayment plan that's administered by the bankruptcy court. So what does it mean for a tax debt to be dischargeable in Chapter 13? Well, it doesn't mean that, poof, the debt's gone, you're never going to pay a dime on the debt. What it means is that that debt gets treated just like general unsecured debt, credit card debt, medical bills, that sort of stuff. So the percentage that you're going to be paying on the general unsecured debt is the percentage that you're going to pay on that dischargeable tax debt. And then at the completion of the plan, provided you do complete the plan, any remaining debt on that particular, any remaining balance on that particular debt is just wiped out. So it doesn't mean in Chapter 13 that the debt becomes zero. It just means that you're going to be paying less than 100% unless you have to be in a 100% plan. And then at the completion of the case, the unpaid portion is just discharged. Now, in Chapter 13, there are a couple of ways to get a discharge. One is to complete the plan, and at the plan completion, you get a discharge. The other is called the hardship discharge, and that is where you get a Chapter 13 discharge without completing the plan. And that comes up if you've had a material change of circumstances that renders you unable to make any plan payments. There's no way that you could possibly modify the plan to have it be feasible in any way, shape, or form. And you've already paid back your general unsecured creditors at least as much as they would have gotten in a Chapter 7 liquidation. And then finally, it's not your fault that this change of circumstances has arisen. The way the code, the bankruptcy code puts it, you can't be justly held accountable or responsible for this change of circumstances. And in that situation, the plan does have to have been confirmed before you're able to do a hardship discharge. But if you've satisfied those requirements, then you can move the court to get a hardship discharge. And in that situation, maybe you didn't pay a whole lot on the tax debt. The dischargeable tax debt is wiped out. The non-dischargeable tax debt then survives the hardship discharge. Now, in a Chapter 13 where you complete the plan, one of the things you're going to have to do through the plan is pay the non-dischargeable tax debt in full. Now, that's typically referred to as priority tax debt, although with priority tax debt, the definition of priority tax debt does not include that 2-year requirement. And I believe one of the questions that we're going to be dealing with a little later on is on priority taxes. So we'll table that detail for a little bit later.